Hello and thanks for joining us in Project Justice this week. I am Mutuba Moran. Our focus on this show would be on the anti-corruption war. Last week, the Nigerian Senate rejected the nomination of Ibrahim Magu as chairman of the Economic and Financial Crimes Commission, EFCC, by declining to confirm him. Magu has been acting chairman of the commission since late 2015, following the departure of Ibrahim Blamode under very controversial circumstances. So twice Magu has been nominated and twice he has been rejected. What does this portend for the war against corruption, especially as it was the report of another crime-fighting agency that partly nailed him? Is Magu really a clog in the wheel of the anti-corruption campaign of the present administration? Did he properly and convincingly defend himself against the allegations contained in the report against him? Barrister Isaac Anumodu has been following developments in this matter, and he will be a guest this week in Project Justice, but that's after this short break.
The Federal High Court has been approached to intervene in determining whether the appointment of the President Comptroller General Ahmed Ali is within the contemplation of the Customs and Excise Management Act. The court is also to determine whether there is any legal provision that prescribes the wearing of uniform in view of the nature of his appointment. The action was initiated by an Abuja-based lawyer, Mohammed Ibrahim, who is asking for the position of the court on whether Ali, who is not a commissioned officer, is mandated to wear the service uniform before the performance of his duty as Comptroller General. The applicant, who is in court by way of originating summons, whether the powers of the Comptroller General can be exercised without the service uniform. A date is yet to be given for the hearing. Ahmed Ali has for the second time refused to appear before the National Assembly in the Nigerian Customs Service uniform. A former group managing director for the Nigeria National Petroleum Corporation, NNPC, Andrew Yakubu, has been granted bail in the sum of 300 million naira and 2 sureties by the Federal High Court in Abuja. Justice Ahmed Mohammed held that for Yakubu to have the fairest treatment in the United States, a life-threatening ailment upon receiving the EFCC invitation is an indication that he is not likely to jump bail. Justice Mohammed also said that one of the sureties must have landed property within the Abuja metropolis, while the other must be a resident within the FCT. Yakubu is also asked to deposit his international passports with the court registrar and should not travel outside the jurisdiction of the court. Yakubu was arraigned on 16th of March on the 6th-count charge of money laundering and false asset declaration. Justice Mohammed therefore fixed 9th of May for trial. An Abuja Federal High Court on Monday fixed 25th April 2017 to rule on the bail application filed by leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, and 3 others. The court also reserved April 5, 2017, whether to vary its earlier ruling on protection of witnesses in the trial. Justice Binta Nyako had maintained that the ruling on bail application would not stop the trial, which has to go on simultaneously. Justice Nyako, however, told the parties that having ruled on secret trial, such will not be reserved. At the trial on Monday, counsel for Kanu Ifeanyi Ejiofor informed the court of a pending application on right of the applicant to be admitted to bail, which he has already served on the prosecution. Counsel for the prosecution, Shaibu Labaran, opposed the application, informing the court of a counter affidavit already filed. Kanu and others are currently on the going trial on 5-count charge bordering on treasonable felony. The trial of Supreme Court Justice Sylvester Nguta also continued last Thursday in an Abuja Federal High Court, and the prosecution called the second witness. The witness, Ahmed Saleh, Chief Registrar of the Supreme Court, enumerated the total income of Justice Nguta from 2011 to September 2016. The Chief Court Registrar, who also doubles as the accounting officer of the Supreme Court, told the court that Justice Nguta earned over 103 million naira as total salaries allowances from 2011 when he joined the Apex Court to September 2016 when he was arrested and charged to court. Saleh admitted that there are no rules prohibiting a judge from acquiring properties. The trial has been adjourned to Friday, 17th of March 2017. The Economic and Financial Crimes Commission (EFCC) on March 16 arraigned the former Chief Judge of Enugu State, Professor Innocent Azubike Umezuleke, before the Federal High Court in Port Harcourt, Rivers State. Justice Azubike was arraigned on the 4-count charge of non-disclosure of assets and false declaration of assets. He pleaded not guilty to the charge. Justice Omotosho, who presided over the trial, granted him bail on self-recognizance in the sum of 2 million naira and adjourned to April 24th. The People's Democratic Party (PDP) has asked a federal high court in Abuja to sack the senator representing Akwa Ibom South Senatorial District in the National Assembly, Nelson Effiong, over his defection to the All Progressive Congress (APC). The party, alongside 15 other chieftains of the party in the state, through their counsel Gabriel Umo, adding an originating summons, asked the court to declare that Effiong has lost his membership with effect from January 19, 2017, pursuant to Section 68, subsection 1G of the Constitution, having defected to APC before expiration of the period for which he was elected into the Senate. The PDP is seeking an order of the court directing the Senate President to declare the seat of Akwa Ibom South Senatorial District vacant. They also want the court to grant an interlocutory injunction restraining Effiong from parading himself as the senator representing Akwa Ibom South Senatorial District in the National Assembly. The defendants were not in court and were not represented by any counsel. Justice John Soho fixed May 11th for hearing.
Thank you very much, Barrister Nubudu, for granting us this time.
Thank you so much.
Is Nigeria on the right path in its war against corruption?
Oh, big question. On the right path in one sense, on the wrong path in another sense. On the right path in the sense that there appears to be a unanimity, a mutual understanding, a mutual acceptance, summarily a mutuality by Nigerians that corruption is evil, that corruption must be fought headlong if we are to make the socio-economic progress we desire to make as a nation. There appears to also be a recognition of this fact by the leading class. And also, along that breadth, we have a president who appears to appreciate this reality and who appears to be putting his right foot forward in the fight against corruption. So to that extent, we can be said to be on the right path. But we cannot be said to be on the right path when we now look at the modus operandi, when we now look at the infrastructure, the logistics for fighting corruption, when we now look at the methodology being employed by the present administration in the fight against corruption, then we're not on the right path. If anything, the methodology is so counterproductive that it might negate the war against corruption. It might not take us anywhere, as it hasn't taken us anywhere so far.
What's wrong with the methodology? Because there are some people who agree with the methodology and say we've gotten to that point in our political history and our national life where if you don't tackle it headlong the way you are doing it now, then you're likely not going to have results.
Well, like I said, if the tackling is headlong, those people will be right. But with all due respect to them, particularly those who are in the Presidential Committee Against Corruption, they either do not understand what the fight against corruption is, or there may be some fifth columnists actually that want to sabotage the president in ensuring that he does not win this war. Because I am beginning to see the president as someone who may really be a sincere person after all. I don't know him too closely. But if the issue and what happened concerning the issue of his ill health is anything to go by, you see a president who seems to like to do things properly. You see a president who has regard for honesty and integrity. You see the man not feeling well enough and taking a vacation to go and attend to his health, and was polite enough to Nigerians to tell us so. And while leaving, he obeyed Section 145 of the Constitution and transmitted power to the Vice President to ensure that there is no vacuum in governance. The advisors, the aides are around to implement. And if they are the kind of persons that tell him that you can ignore the rule of law, you can ignore due process, then they are misleading the president. That is why during the last roundtable on anti-corruption, you had the chief judge tell the committee and the roundtable, including the vice president that was there, point blank, that the only way you can fight corruption is by following the due process of the law, by following the rule of law. And if you don't like any particular law, you amend it. You have an EFCC that is supposed to be fighting corruption. Once you fight corruption, Nigerians are going to support you. But once you fight as though you are pursuing a vendetta against some perceived enemies of the government or against some persons that are not in your good book, it will be clear because the Nigerians are no longer as ignorant as they were 20, 30 years ago.
But could the perceived overzealousness of the EFCC not have any linkage to what they perceive to be the body language of a president who is very passionate about fighting corruption, and perhaps the chairman of the EFCC or the acting chairman of the EFCC is trying to impress his boss to say, look, I'm just fighting corruption just the way you want it?
They are, if that's what they are doing, they are apparently impressing the president the wrong way. What? If, from what I've just said, I see the president as a man who wants things done properly, who is apparently a man who wants to create the semblance of honesty in governance, then that man would certainly have wanted to follow due process. If, for instance, in traveling abroad, he knows the constitution requires him to transmit power to his vice under section 145 and he obeyed, that same man will not tell the EFCC to ignore section 36 of the constitution, which says that anybody accused of any criminal offense is presumed innocent until found guilty. And the same EFCC, aware of the provisions of that constitution, having lawyers in his employ who knows the law, will still go ahead and arrest someone as they did with Obanikoro. Arrest someone for allegation, detain him, in other words, and impose a condition that he must deposit 100 million naira before you grant him bail. In other words, you have found him guilty. In other words, you have concluded he actually took the money. He has the money from where he must bring out 100 million to deposit before he can be granted bail. Now, that is the way the war against corruption is being fought under the present EFCC. And that is why most of the senators feel that if that is the approach, this is not the kind of war against corruption we want. So it's not about corruption, fighting corruption. No, it's about the modus operandi, which is antithetical to the maintenance of fundamental human rights and other, innate principles of our constitution that makes us a democratic society.
It does appear that it's quite difficult to rule out excesses in situations like this. Are there no institutional safeguards to protect against such excesses?
That is why you see some of us were very livid when the DSS did that raid against the judges. Because the judiciary is the last hope of the common man in situations like this. That's where anybody whose rights has been put upon, or wherever the security agencies have overreached themselves, could run to for reprieve. But when the same judges are now themselves being hounded, being blackmailed, being harassed, you break into a judge's house at midnight, bundle him like a common criminal. How will these judges have the courage to dispense justice? Particularly when some of those judges, like Justice Dimba, was a judge that had been carrying on his job with diligence and integrity and courage. And for the records, orders against the DSS.
For the records, it has just been cleared by the NJC.
I'm not surprised. because we know Justice Dimba. We know we're not saying that there are no one or two Judases among the 12 disciples in the judiciary. We're not saying that there may be no, one or two bad eggs. But they are so negligible. They are so much in the minority compared to what goes on in the legislature and the worst that goes on in the executive, with all due respect. So if there is any place where the searchlight on anti-corruption should be beamed, it should be the executive. So for Magu to fail to do that and be concentrating on the legislature and even the saint among the three arms, because if you compare the judiciary, the legislative and the executive, the judiciary is like a saint in governance, better than the other two arms. So for Maguto and the DSS and the present EFCC to concentrate on the judiciary, then it was not a fight against corruption. The whole intent was to intimidate the judges, intimidate the judicial arm, so that it will not provide the requisite checks and balances against the intended or ongoing excesses of the executive. And that is what every Nigerian must deprecate. And that makes that question you have asked now very relevant. So moving forward, therefore, there must be a retooling, a rekitting of the entire anti-corruption war. First of all, the president, with all due respect, I'm advising. He can take my advice. He may choose to throw it away, but that's the view of many Nigerians. That so-called Presidential Action Committee Against Corruption, or whatever it's called, headed by Professor Isesage, should be disbanded immediately. They have achieved nothing. They've been of no help. They've rather rolled back the wheels of the anti-corruption war and the success that have been made by the ICPC and EFCC and other agencies of government that have been involved in the fight against corruption. Secondly, there must be a deliberate effort to strengthen the judiciary so that it can deal with these perceived excesses as it is in the United States. You could see how President Trump, in his zeal to put America first, immediately issued presidential orders, banning immigrants. But people could go to court, and the court, district judge, could make an order stopping Trump, and that order is obeyed immediately.
That's checks and balances.
Checks and balances.
All right.
We don't have that efficacy of that check right in Nigeria, and the only way to get about it is there must be full independence of the judiciary in terms of funding, complete independence. Also, in terms of method of appointment of the chief judge, the recent incidents has thrown up an innate incongruity in our law, which needs to be amended immediately. That is the provision of section 231 subsection 1, which requires the president to submit the name of the chief judge to the National Assembly for confirmation. That, for me, is wrong. If we are talking about having three independent arms, the executive independent, legislature independent, judiciary independent, then nobody and no other arm should be responsible for choosing who becomes the chief judge of the federation. For instance, when the president is appointing his ministers, he only sends their name to the National Assembly for approval. He doesn't send to the judiciary. When the National Assembly is electing its principal officers, it does that by itself without consulting the judiciary. Why should the chief judge be the one that the president must nominate first? National Assembly must confirm second before it's appointed. That subjects and makes the judiciary appear inferior to the other arms. And secondly, the issue of immunity under section 308. That clause. So, apart from section 231, section 1 that must be amended to take away the role of the president completely in the appointment of chief judge to avoid the last experience we had, section 308 should be amended also. That section that provides immunity for the president, the vice president, the governors, and deputy governors should be amended to either take away the immunity clause completely and make every government official answerable for their actions. Right. That will lead to integrity and probity, or if we have good reasons why it must be retained, then the same way immunity is good for the president and the vice, governor and deputy, it should be good for the Senate president and deputy, speaker and the House, deputy speaker, House of Reps. It should be good for the speakers of the State House of Assembly. It should also be good for the chief judge of the federation and chief judge of the state, so that these three arms can be truly independent and provide the checks and balances contemplated by the Constitution.
So you're watching Project Justice. Let's take a short break now. We'll be back. Do stay with us. Welcome back. Still watching Project Justice. What is your reading of the recent rejection of Ibrahim Magu as the substantive chairman of the EFCC by the Senate?
My reading, I perceive to be the reading of most Nigerians, that the Senate has done the proper thing. If the Senate of the Federal Republic has been carrying on in this apolitical manner, I'm sure Nigerians would have grown to acquire more respect for the Senate. This is one issue where you didn't see so much of APC, PDP, North, South, East, West, religion, no religion. What mattered was the issue at stake, the institution of EFCC and its leadership. And the question is simple. Is, with all due respect, Magu qualified to head that sensitive and important agency called the EFCC that is playing a pivotal role in this war against corruption that we have all acknowledged to be important at this time. And it was not difficult for anybody who watched the screening to see that Magu, with all due respect to him, performed abysmally. Even his supporters, Senator Ndume, who was even trying to see how to salvage the situation, admitted that he didn't do well during the interview. All he said was that he's not a journalist or he's not an actor and he was not required to act. But you don't need to be an actor or a journalist to answer questions relating to your job. He was asked, this is the EFCC that has been telling us every day how many billions, how many millions, how many dollars, how many pounds have been recovered. And you are now coming for interview when you know you'll be asked questions on matters relating to your job. You should not only have come there armed with facts and figures, you should even have come there armed with statements, CBN bank statements of all the monies lodged there by EFCC, recovered by EFCC, only for him to be asked how much has been recovered so far, and he could not say the amount. Now, this is anti-corruption war, and you are the chairman of the anti-corruption agency. You are like the anti-corruption czar. And like Caesar's wife, you should be above board, above suspicion. And you are now being accused of corruption. And the senators are mentioning the name of the retired military officer who is his friend, who is of questionable character, and who is said to be, his front, through whom he has been collecting bribes.
Whom he has also denied he doesn't have any friendship with the person.
No, he didn't deny. He said he knows the person. He said he mentioned the time he knew the person about 2 years ago and the circumstance under which they met.
In the course of there being membership of the presidential panel,
he said that was how
on
they
investigation
met.
of arms.
Yes, he said that was how they met, how they knew. But what transpired after? The senators asked him clearly, what is your relationship with this man? And how do you respond or answer to the allegation that this man is fronting for you to collect monies and bribes on your behalf?
But he denied that.
No, he did not deny it. I watched the proceedings, sir. If you have the tape, please play it. He only said that he never knew this man before that 2015 committee, and that was only where he met and knew the man. And he stopped there. He didn't go beyond to say, beyond this meeting him there, I have had no dealing with him thereafter. I've never met him again anywhere. As alleged, he cleverly avoided saying anything about this prime person that was mentioned in the DSS report.
But the rejection of Magu, as much as a lot of people would say, oh, the just a minute, the Senate has done well. It has also polarized opinion because, on the other hand, you find people who are saying, under Magu as acting chairman of the EFCC, we've seen massive recovery of monies. What is your reading on that as well?
No,
because I know it's a bit controversial, because if you said you recovered so much and you were asked how much have you recovered and you can't state it before the senators.
That's the point. That's why those of this hype about Magu's proficiency, efficiency, blah blah blah. Those of us who are learned minds, when you analyze it critically, it doesn't stand. Media trial is not trial. Okay, look at the judges, for instance. The EFCC told us they did a sting operation. It has been so analyzed not to be a sting operation. They told us they had credible intelligence and information about these judges. And at the end of the day, you are prosecuting only 2. Even the 2 you are prosecuting are all filing no case submission. And some of your witnesses are coming to admit that the same way lawyers gave gift to one of the judges, that is also how the president's lawyer also. There was not this media trial under the President Jonathan's administration when he set up the ICPC and EFCC, and under Obasanjo and then President Jonathan. But still, under those administrations, we had serious convictions to the point of the deputy national chairman of the ruling party, the PDP, being convicted and sent to Kirikiri prison. Here we have a Magu who is fighting corruption. And the only person that is a member of the APC that appeared to have been arrested for corruption was one Alhaji Issa. The moment the man appeared to become the friend of Mr. President, he was released the very next day, in fact, midnight that day. After Magu had to be summoned to the villa and had to go and come 4 times in one single day. Is that not double standard? That's not how to fight a holistic war against corruption that you want all Nigerians to buy into, without which the war will not succeed.
Barrister Numudu, what is the fate of Magu at the moment? Because we appear to be at the crossroads now where people are saying the president can resubmit him or his name to the Senate multiple times, while others are saying he and the process ends as we speak at the moment. Legally, what is his fate at the moment?
There are no crossroads, with all due respect. What I see, however, is a new but dangerous dimension of politicizing everything in this country, including something as sensitive as the post of the chairman of EFCC. You saw how some of us rose against the recent attempt to even politicize the appointment of the Chief Judge of the Federation. And a seamless, innocuous, harmless procedure that should have gone on without distraction was almost allowed to heat up the polity and cause multifarious and monumental distraction. That's what's happening here now. Otherwise, what's the big deal about the Senate rejecting Magu as required by Section 2, Subsection 3 of the EFCC Act? All that it will require is for Magu to go back to the police. It has not taken away anything from him. Magu still is a public servant. From what I gather, he's still an assistant commissioner in the Nigerian police force. It's not that that means sacking him. It's not that that means convicting him. It's not that that means imprisoning him. All it means is the Senate says we have found you unfit to be the chairman of EFCC. Because the law, Section 2, Section 3 says that the chairman and members of the board, except ex-official members, shall be appointed by the president subject to the approval of the Senate. So the law is clear, no ambiguity. You cannot be chairman of EFCC unless you are, one, appointed by the president, which he was appointed, and two, approved by the Senate. And the Senate said, no, we will not approve you for these reasons. The 14 allegations contained in the EFCC letter on the one hand, and his inability to answer clear-cut questions that were put to him. It would have been different if, when these allegations were put, he answered them logically, intelligently, and made admissions where there were lapses, and promised to redeem those lapses, and gave a roadmap as to how, moving forward, the EFCC will, meet the yearnings and aspirations of Nigerians who want corruption fought holistically and, totally. That's not the idea of fighting corruption in a democratic. They are fighting corruption in America. They are fighting corruption in the United Kingdom, but it is not being done like this. All right. So, and again, the fact that we're even debating is worrisome for the development of society. So the fact that these few bad eggs are trying to tarnish the image of the country requires that the anti-corruption war be fought holistically, frontally, transparently, dispassionately, without any hanky-panky that will mitigate against its success.
We might just have to end it there. Thank you so much, Barrister Anumodu, for your time.
You're very welcome. Very welcome. Thank you for having me.
Well, that's Project Justice for this week. Thank you so much for being a part of it. Be sure to send in your contributions and your comments on the various social media platforms on Twitter and on Facebook. Remember, our Twitter handle remains @ProJusticeLive. On behalf of the entire production crew, I'll see you next week. I am Buhari.